So you've actually got to be kidding me with this. So this is the actual Juries Act 1974. The Juries Act 1974. I've really been interested in the oaths, because the Claim of Right, Scotland, 1689, is full of oaths. It's like a large part of it is about oaths, and that's the act where basically you're not supposed to do favours for people for lowered sentences, particularly to get information from the accused. And that act is focused on oaths, really, and that in the judge's oath it's about not accepting favours, which is letting people off if in return for giving evidence or for reducing sentences, which I don't think that you're allowed to. I don't think you can say, we'll give you £60 fine if you just, admit you did it. And if you do it within 10 days, we won't make it £80. That is basically what it stops in the Claim of Right. So that's how I got interested in oaths. Richard Verb's programme had been talking about oaths, right? And a lot of those people that he has on talking about freemen. And I know that the Ministry of Justice do not like all this Richard Verb's programmes about freemen and oaths and so forth. But I'm not, the way they talk about it in their programmes, I don't really know what they're talking about, to be honest. Well, a lot of what they talk about seems kind of not in the way that I approach law in general. I approach acts of law like, I want to understand the law, basically. I want to learn, the law, and then, basically, these guys are, a lot of people, these people talking about freemen. I'm not trying to write the law off and say that the law is a load of rubbish or not valid, but I'm trying to, I want to understand it and make sure that you can do what you're allowed to do and you don't do what you're not allowed to do. But, fairly and justly, properly, particularly when you've got rights. So when we got onto the oaths, and I learned about the oaths, and the judge's oath, doesn't do favours and so forth, that's got to come from that Claim of Right, because they were all over those favours, and it's full of oaths. So something happened, some incident happened, and they put that in there. And the word blackmail comes from the north of England, and the south of Scotland, the origin of the word blackmail, to be blackmailed. And there are several suggestions in the Claim of Right that refer to kind of like the situation where we get blackmailed. It's like giving over money or facts or evidence in return for something, but it's like done kind of like, you kind of like forced into it sort of thing. Which is what they were doing in the Claim of Right. They were forcing people in to give evidence. So, on themselves for reduction in penalty and punishment. So, anyway, so the police officer's oath, the Scottish one doesn't have an allegiance to the king, but the British police oath does. But he basically, it's the oath of upholding the law to the rule of law, and it also includes your rights as well nowadays and so forth. So, but the judge's oath is also interesting. Now, what I realised is, I've taken an oath. I said we have to take oath at Cub Scouts, and it's basically an oath of allegiance. It is an oath of allegiance, and also, but also to God, and under the Christian faith, and also, what else am I thinking? It's also basically to uphold the Cub Scout law, which is basically of personal integrity for honour, to be kind and good to people, tell the truth, and help people which is what I've actually been doing through all this, really, I suppose. And, well, I have. And it says keep this Cub Scout law. Now, if the Cub Scout law is that you've got to be honest and kind and not lie and, not be deceptive, and so forth, this is the thing. I'm wondering what validity it has in legal terms, because, when you write, when you submit evidence and so forth, and you get into representing yourself against the CPS, and you put legal statements, you're meant to put the statement of truth. I do solemnly swear that I believe this is the truth and fact. So if you're swearing that you're an honest person, firstly, if you've taken an oath with witnesses, that includes that you will always be honest and tell the truth, and that, I believe, everything that you do is an oath to be the truth, and of honesty and integrity, you've effectively made a permanent oath without having it discharged ever, that basically fulfills all the requirements to submit legal documents and fill them in, and permanently validate legal documents. You've effectively, so your oath, the Cub Scout oath for certain, with the integrity aspect of the Cub Scout law, the clauses of the Cub Scout law, which you're swearing an oath to, permanently in your person, in yourself, any evidence or testimony you put in writing is automatically legally valid, without you having to put a statement of truth at the end of it, because you've already made an oath to that. I can tell you that for a fact. So you're supposed to have allegiance to the king and country and to God. Now, the thing is the king being honest to his oath to this country? That's the thing. And are the police being honest in their oath to this country when they're putting out the equipment and setting the road signs up, unlawfully and things like that? So it doesn't particularly say you've got to uphold like the legislation of England. Now, the thing is, with the Cub Scout, I've just realised this as well, it's quite significant, that you can't be prosecuted, can you? If you're under 10 years old, you've got immunity. If you're under 10 years old, you've got immunity. You've got immunities anyway. You're like a little baron, basically. You can't be prosecuted if you're like a little kid. Effectively, you're like kind of a little lord, really, in law, because you can't be prosecuted or charged for being a criminal. So it kind of is quite a novel idea that you have little Cub Scouts taking an oath while they're little, whether they're 8 or 9 or 10-year-old or sometimes younger. Well, our Cub Scout was next to play school, and you go to play school around the 4-year-old, 4, 5, 6 sort of age before first school. So that must have been when I was in Cub Scouts. So effectively, you're taking an oath where, for life, really, without it being discharged, you're good for giving legal statements and documents, in effect. So, and obviously, until you reach 10-year-old, and then once you get older, then you become you kind of lose your legal immunity. This is when you get into the juvenile courts and so forth, but I didn't really get into any trouble when I was little or when I was in my 20s, really, either. Only these driving scams, which I've now found out the very first time I ever got a driving charge in Oldham on top of the moor or bottom of the moor. It's called bottom of the moor. Bottom of the moor. Going out of Oldham on the Huddersfield Road, and that was a traffic light. And then I never saw it go off, and I wasn't daydreaming or anything. It never flashed, and I never saw a red light. I never ever saw any red light or lights change or anything. And later on, that's when I very first started driving. Well, it's when I first started driving for work, and later on, when it got to this campaign, which is towards the end of my driving career, I guess, that's when I found out that traffic light had a strategically placed post obstructing the view of the traffic lights at the exact distance that they're supposed to be visible from. So if you get the tape measure to where you've got to have a visible line of sight from this point, that's where the sign was put there to block the line of sight. And it was exactly there. So it ironically, when you actually get to the exact place where you've got to see the traffic lights from, legally you've got to be able to see them, you can't see them if you're in a certain lane, the inside lane. So I found that ironic. So that's enough to make the setup unlawful. It's enough to make the configuration not lawfully placed, and also dangerous in a way, because you can't see them at the prescribed distance they're supposed to be visible from. At least not when you're coming into them. So it's setting you up all wrong. I don't think that sign obstructed them though. When I was there, it was it was in place, but I may or may not have been in that lane. But saying that, I just don't think that. I don't think that they went red. I don't believe that they went red. I don't believe that there was an incident. I just think that, you know, they just took a photograph with the camera and sent it, you know. And if you want to say, well, in the photographs the lights were red, but I never even got those photographs. I never even applied for them and even really know what a speeding fine was. To be honest, in my driving lesson, we never did fines in cameras because there weren't really any around at that time. And in fact, I think Oldham and around Denton and that area of Manchester, that's the kind of like one of the first places in the north where they had them. But, you know, if you want to say that, you know, was that traffic light lawfully set up? No, it wasn't, you know. So it was a mysterious one, and that's the first time I'd even really encountered the police or the law or fines or prosecutions. It's almost like, you know, you get introduced to it when you start driving. I think it's a setup. I think it was like a setup, like you know, just a little gimmick thing to you know, get a few people who were savvy. That's my opinion. Obviously, I'd have to prove that, but I would, you know, suggest that it not being lawfully signed as to prescribed regulations, there's surely quite a large number of fines that would be unlawful at that site anyway. Anyway, I ended up telling a story then, didn't I? So the oath. I mean, so I know that, so in law, the oath that you've got to take to be a juror is in the Act. So obviously, you know, to be a juror and to be sworn in on a jury in a court, you've got to take the oath that's in the legislation, obviously. And to be a judge, it's legislated for that, and obviously for the police and so forth. But when you start looking at submitting legal documents and it says they've got to have a statement of truth on, but what is it saying? It's saying that you've got to put in writing a statement that you attest that what you're saying is the truth. Now, if you're taking an oath of that, the question is the oath that you take an oath that you're attesting that what you are saying and doing is the truth? Well, yeah, either it is or it isn't, you know, and that is what makes it have any validity or not to it. I think Baden-Powell, obviously he was a member of the House of Lords, and he got lawyers in the family, King's Counsel and so forth. They clearly had some, they knew what they were doing, and they had, like, you know, a legal background and education and, you know, King's Counsel and so forth, and then also a member of the Lords. So then they're getting basically little kids to take oaths to be good citizens, basically, and I don't think it's messing around. If you're taking an oath with witnesses that a member of the House of Lords has devised, and it is an oath that you're not discharged from unless they discharge you from it, and you are, you saying that, you will be honest and tell the truth, that's an actual oath that you're doing to that. It's not just like I don't think that it's a proper, it's not like when you're, many times when you fill in legal documents, you're by yourself anyway, you put it in writing, but it's different if you do a proper initiation ceremony with proper witnesses. You're actually being sworn in. So, I think if you're taking an oath to God and to the monarch, but obviously, if they're not keeping the law, then surely, you've got to tell, you've got to say they're not keeping the law, or if someone else is breaking the law, that's a little point, isn't it? So I got interested in this Cub Scout oath. So I think that it has got some sort of legal effect. Obviously, if you haven't been discharged from it, it has some kind of legal effect. So now I just want to mention that, so I learned about the Representation of the People Act, which is for elections, but it's also got some clauses in it, about prosecutions as well for petitions to Parliament. It's also got illegal police canvassing in there, and also designating a vehicle for use in elections as well, when it's got a sign on it stating that it's been used by a candidate, or on behalf of a candidate for those purposes. And then obviously the later acts evolved from there. But what I found, I've just actually read this now, and I am absolutely amazed and surprised that when I've started looking at the oaths, I come to this Juries Act. I've kind of been going on a bit now. It's 16 minutes. I didn't want this video to be that long. So this Juries Act, 1974. Now, this is the thing. I've had this hunch or this intuition that looking at the Tumultuous Petitioning Act and the basis of petitioning the king, you're bringing a case, and the fact that he had to go through a court in the Tumultuous Act until it was abolished, and particularly if you've got over so many people signing it, it's lawful due process. And if it's a petition to the House of Commons, we know that election petitions to the House of Commons are recognised as being under that jurisdiction. So the other petitions have to be, because that's the point. Now, this Juries Act, it actually refers to the Representation of the People Act. And, I thought the Representation of the People Act is only really relevant to people who are, getting elected, because I'd never heard of it before. But obviously it's the Representations of the People Act. It's about people themselves making representations, not just electors or candidates. The people are voting them in, by ballot. And so I'm quite surprised, if not kind of intrigued, that the Juries Act of all acts refers to the Representation of the People Act. So it's relevant. Representations being made by the public or the people is relevant on the subject of juries. That is noteworthy. It's more than noteworthy. And also, because they are on the electoral register. So it's people who are on the electoral register. If you're on the electoral register, you are registered with the government to be a voter and an elector, but also you're recognised. So what I was saying is, it's all to do with the electoral register, basically, which basically means that you're a citizen of the realm. You're a citizen of the realm and a subject of the king. That's why it's a Representation of the People Act with the Juries Act, because, if you're on the electoral register, you are a subject of the realm. Otherwise, you don't really. I've never been selected for jury. I don't know whether it's because of a driving charges, even 3 points, they might not have people on it, or just look at the draw. But you'd have thought that, you know, I mean, how many people are there? How many juries do they have? I think, you know, surely, I don't know. I mean, I'm starting to wonder if they keep within certain circles. And this whole point of the fact that they can, if they're short of people, they can pick anyone from who happens to be passing by. He could be set up. Anyway, so now the oaths. You can have oaths that are taken in public that have, you know, effect, particularly if it's a special group, like what Baden-Powell, you know, he designed it to function and have some kind of effect as to the character and behaviour of, well, to have an effect, basically. Well, that's the whole point of it. You know, he designed the oath to be taken and to have effect and to be used. And you know, this is a member of the House of Lords and the King's Council, his brothers. So they kind of like knew what they were doing in legal terms of writing statements, issuing statements. Like I said, I know for a fact that oath is good for. You're good for writing statements and giving evidence on that oath without having to make any further written statements on paper, because you've taken an oath. You've been charged with that oath, so you aren't required. I don't think you're required to put it on paper. Some courts require you. They won't accept the evidence, or they can reject the evidence if it doesn't have it attached. I know a lot of people don't bother to put it on there, but I did when I was doing my legal submissions. I put it on there, but actually, all my material will be good for it without me having to write it on there. So the Representation of the People Act. Now, this is why I've recorded this now and started recording. So there is aged under 18 or aged 76 or over. So you've got to be a certain age to be a juror. But, right, this is the thing. Was Representation of the People Act. Electoral register as a basis of jury selection shall, as soon as practicable, the publication of the register electors for his area delivered to such as election slave may designate a number of each day. If registered to the electors, where's this? The right conferred by subsection 2 shall not be exercised. The trial of jury is no longer possible for there to be a trial by jury. Right conferred by subsection 2. A party to proceedings in which juries are or may be called to try an issue. Well, they can't be called in Parliament, can they? This is the thing. I'm reading this now, right? I'm looking at it in terms of framework of the public convening either as a jury, or from an other position. Because if you read the words of this, right, you're party to proceedings if you're petitioning government. You're a party to some existing proceedings. We know that. A party to proceedings in which jurors may or may not be called to try an issue. Well, if this is the thing, if you're petitioning Parliament, the House of Commons, they can summon witnesses. They've got the petitions committee has got power to summon people, and it's got the power to subpoena stuff, and also refer matters to a court. But what court? Well, it's a high court, isn't it? That's the thing. You know, like with the with the elections petitions, this is the thing, and it won't be with a jury. I can guarantee you that if it's in the high court, it won't be in a jury because it's a high court, isn't it? Well, you'll get 3 justices. You might even get Miss Lady Spider Cobweb, whatever she is called, if you're in the Supreme Court. And Parliament, this is the thing. Parliament can put bills through and so forth for legal matters and orders if people petition, like with, you know, John Beswick and Henry Burton, who got their, John Pym got them acquitted through House of Commons for putting a bill through, or however they do it. Well, that's what Richard Tice said. They can put a bill through, get it passed. You can have Privy Council as well. No, there's where's that? Person of image from this act makes it cause it permits made in his behalf any false representation. A person having been summoned under this act makes or causes or permits to be made on his behalf any false representation to the appropriate officer with the intention of evading jury service. You can't evade jury service. So basically lying. I'm quite sure that they've got the jury have got immunity from any other offences that they might have committed, because they're not on trial. If they might end up, because that's the thing. This is like how it all works, right? I'm quite clarified about this. So, like, you know, like in the claim of right, it says that you can't be forced to depose on yourself. Like, you know, give evidence against yourself. You can't be forced to do that for reward or favour or whatever. You're doing a fit. So, like, you got to imagine this, right? This is quite an important understanding of the dynamic of what is happening. So, if you get called on jury service, right, you're not on trial. You got called there randomly, and you get, you know, made a juror. You can decide whether the person's guilty or not, and so forth. You're not on trial. Now, this is the thing. You're doing the court a favour, and you actually also get compensated for it. So you are doing them a favour by turning up and doing the job. And you can't be forced to depose on yourself. So if you did, you know, if something came to light that you committed a crime, you're not on trial. So you've got immunity from that, you know, if it turns out, you know. But I don't know if you can be selected if you're a criminal or not. This is the thing, but they might not know. You know, you might not be. Well, obviously, I don't know if you can be. I'm not sure if you can be chosen if you've got a criminal record, which maybe the police chief liked to, you know, notch up drivers, and you know, people who are pro. This is the thing. I'm starting to wonder if they were knocking people off the jury service list if they've got driving offences, even if it's just speeding 3 points, because then those people would be like, you know, pro. Well, they're people who you know have been known to speed. So if you had juries with those people on them, they might be sympathetic to people who have been speeding, and they might be likely to acquit them. And if they're doing massive numbers of speeding charges, I know that you first got the magistrates court, but I guess you can always appeal it to the Crown Court. You don't really want people who are pro speeding. This is why they like to do speed awareness courses and try change people's attitude and opinion and get them to not like people who are speeding, which that really could be, you know, depending on what your opinion is, the police are really trying to change your opinion, really. almost training people to not like people who speed, which is you're getting into politics in policing, which is getting into illegal canvassing. And then, if that were to affect juries, it were groomed by police chiefs, and they were to be trying defendants. How can you be impartial if you've been groomed by speed awareness courses to not like people who speed? Given on the fact that, you're supposed to formulate your own opinion, even when you go to vote, for political parties and so forth. This is why I don't like the police, and I think the police, when they do these public grooming setups, because this is what the police have learned a lesson with Extinction Rebellion. A lot of Extinction Rebellion are all kind of like, they're psychologically conditioned into the they're all believers in the cause. And one of the things the police are really preaching, they're doing a bit of religious practice, that they're effectively trying to get believers in their cause, which is semi-religious and semi-political. They're dabbling in religion and politics, and with a front of road safety. They're educating people on safety, but the problem with that is it gets close. It skirts or gets close to the edge of politics and religion, and you can have a fire safety session, or cooking health and safety, but the thing is, these people are facing charges or prosecution, or have had this instead of charges or prosecution. And the thing is, you can have a political opinion where you might not want speed cameras, but after you've finished with the speed awareness course, you might not. Now, you actually could do a scientific control blind experiment. If you got 1,000 people, right, who went to the ballot box and voted, if there's one MP who was like saying, I'm going to get rid of the speed cameras, and one who wasn't, and you're free to vote for either MP, right, depending on whether you think there should be speed cameras or not. If you got those 1,000 people and sent them to speed awareness courses, and then afterwards, when it was time to come an election, no one voted for the MP who wanted to get rid of the speed cameras, then in a scientific experiment or psychology, you could guarantee that a professor in law or in psychology, could determine that those persons had been groomed and influenced in their opinion by the police, and therefore they didn't vote for the MP who was going to get rid of the speed cameras. Therefore, you could prove in a high court that the police politically groomed and affected the outcome of the election, because it's an experiment and it's science. And if you prove that the people who were going to vote for one MP or another, then none of them voted for the one MP, because if you found that it was because of the speed awareness courses, then the police have successfully affected the outcome of the election, and that would be illegal, criminal. It would become like police canvassing in the Representation of the People Act, which actually is referred to in here. And that would be illegal on television, but it's not done on television. It's done behind closed doors in hotel rooms where they have these speed awareness courses at the Dram Centre and so forth. So there's a case for that. I mean, that is a case I'd like to try if I had the money. If I had £1 million spare from the lottery, that would be a good case to try in the High Court. Have the police been affecting the outcome of elections? Obviously there would need to be an identifiable candidate who wanted to get rid of the speed cameras and one who didn't, and then you would have to show that a certain percentage of the people have been on these speed awareness courses, or even the television have been trying to change their attitude. But this is when you're getting into television and influencing people, loose women who have been influencing everything from food to baking to the whole thing. But I'm going off subject again now. I have been having been summoned under this act makes because right. So basically, what I'm saying is they've got immunity from other offences that are not related to the case. If it should come to the attention of the court that any of the jurors, committed an offence, they're not liable. I think that's what the immunity covers. But obviously, they are liable if they lie about false representation or like, I think that's like, if they pretend they're ill and they can't do it when they're not ill or something like that, or the Public Order Act 1994, criminal justice and public. So that the Public Order Act, I thought the Public Order Act was brand new. That new one they've done is just like an update or an amendment to it, so they've already got them. Be liable on summary conviction. Hold on a second. So what I wanted to look at is this section here, right? It's called the ballot and swearing of jurors, section 11. Well, the ballot and swearing of jurors, they use ballots for it. So they're actually using a ballot to select persons in connection with legal cases and who's going to be the jury and actually the people who are responsible for making decision beside the judge, which is quite a responsible position. But it's done by ballot. So there's some kind of balloting going on there. Again, the Representations of the People Act. So because this act refers to and mentions the Representations of the People Act and Electoral Register, we're looking at citizens of the realm who have got a right to vote and who are subjects of the realm, processes that are by ballot and eligible citizens, but also oaths and making decisions in legal cases, right? And it also involves amounts of immunity and so forth, but also liability. So the thing is, when you get onto this, you're on the subject and area of proceedings and citizen eligibility, rights, oaths, and also immunities, also judicial powers as well. You're on that area of subject precisely and exactly. So when we're looking at the right to petition, it's a right, it involves some kind of immunity because it's included in the petitioning right, illegal prosecutions. So that it's in and around the same area of eligible subjects, legal proceedings and immunities, and also getting people to sign the petitions who are also eligible on electoral registers. So you're on you're in the right area of you're not in a butcher's shop buying a sandwich. You're close to the bone of the structure and framework of courts and proceedings in England. And what I find about this 11, jury to try an issue before a court should be selected by ballot in open court. Now, the power of summoning jurors in this section that may be exercised after balloting. So, what was B? I don't even think the old act's available at the moment, and that's probably likely important to know what that said. So, if you look at, this is what I wanted to get to, and I've been going on a long time now. I actually read this before I started recording, and now this has ended up being in 4 parts. So this 5C of 11. So in 11, the ballot and swearing of jurors, 5C, right? The wording on this. In a criminal case, beginning with a special... So, memory card filled up again. So, in a criminal case, Well, it's saying criminal case. You can have other cases besides criminal. You could have a civil case, but there are also political cases. A case with aims that are to the making or changing of the law of England, or for procuring an action from a minister, such as a public inquiry, or the changing of the tax is the change of the law. You can have a case that is not criminal or civil. There are other types of cases. A case beginning with a special plea. Well, the thing is, when you bring a case to the House of Commons committee, you are bringing a case, and it's a special case you're bringing, but you don't have a plea though. But it begins with a special right, and you set out that you are petitioning the king, which is kind of like, yes, I hereby, petition the king through the 1688 Bill of Rights and so forth. That's an oath and affirmation. The petition itself is like, when you put your statement of truth. The statement of truth is relevant because when you write something and say, I swear this is the truth and fact, when you write the petition supposedly properly, you write the petition that, I petition the king under his rules and his laws, that you will abide by and proceed with for the petition, and pursue on the set out, make your case, and then get the electors to ballot the electors to sign up, witnesses to sign it, and with special provisions in law, and then you attest that it is the truth. So with a statement of truth, people don't bother writing that on. And ironically, in the House of Commons, when they do the electronic petitions, they don't put the statement of truth on the end of it. They add that on themselves. You would have thought they would. I think they probably likely do that on the Northampton, on the small claims court. They probably put that on there. But the thing is, I don't have to write a statement of truth down in writing every time I write a statement because I've taken an oath of truth. So I don't have to write it on paper like anyone else because I've actually already done an oath to the truth, which I've been discharged from it. So certain persons who don't have to actually bother writing it down, because I've got an oath to the truth. So on the petition, when I write a petition, it's automatically got a statement of truth on it to His Majesty the King by the Majesty the King's procedures and rules. So, that's something. It's not nothing. And this is where I'm starting to think that, where all the immunity and everything is relevant. Because it's a case to the House of Commons, beginning with a special right and ballot of the people, and making a case, and with oath and affirmation, with allegiance to the king. You're bringing the case in the trial of the accused, but you're not accusing anyone of anything. Well, you might have a grievance with the government. The thing is, you actually can bring grievance against the government. So you're actually accusing the government of doing something wrong. Like, I guess they're accusing Sadiq Khan of taking people's money from them from these cameras. So they're accusing Khan. The mayor is the accused. Ironically, the mayor is being accused of, bringing these cameras in, and the people don't want them. In that particular petition, which is also listed to the House of Commons, and you can actually bring grievance against the petitions committee are trying to say you can't bring grievance against any identifiable individual, which there's nothing that says that you can't bring. In fact, it's meant to be to bring grievances as well. Evil ministers, judges, or councillors. And to be honest, when you complain to the Judicial Conduct Investigation Office, you are bringing a grievance against the judge, but by petition to the High Court. Well, I guess it is a petition. It's a grievance. That's a petition, really. A complaint to the Judicial Conduct Investigation Office is a petition against a judge. They're accused of breaking rules. The general issue by the jury in a special plea. What is a special plea, though? Well, you can have guilty and not guilty, but then you used to have habeas corpus. Is it habeas corpus? What was the other one? There was like, there's a plea where you enter no plea. You don't enter a plea. The thing is, you're the one bringing the case, ironically, and you're accusing someone else of something or not doing something, or you're requesting something. So that's the ironic thing, you know. And I don't think it's in front of a jury. Caught me on the trial of the second or any subsequent parties proceedings. In a criminal case beginning with a special plea, they're playing on that because there's something in this, and the fact that they've got the Representation of the People Act cited. In a special criminal case, the accused by jury trying. Is it the jury trying the special plea? The jury trying the special plea. The jury trying the special plea. So if you don't enter a plea. Well, the thing is, guilty or not guilty. The thing is, if you are bringing in a case to Parliament, which is neither criminal nor civil, it's actually it's a special case. It's a special case beginning with a special right. You won't be making any. You're not making any pleas because there is none. Because you're not being accused. And even if there was, if you can't be prosecuted, then why would you be making a plea if it's illegal to be prosecuted? You wouldn't be making a plea, would you? So anyway, I think that there's some interesting wording in this, given the fact that it brings in the Representation of the People Act into the Jurors Act. And it basically, what I'm trying to say is, the wording on C here, the wording on 5C is, it reminds us of the fact that if you're petitioning the House of Commons, you're bringing a case, you're not having a case brought against you, and it is a special case, and you won't be making any pleas because apparently, he supposedly can't be prosecuted. So why would you be entering a plea? Now there's something special about that, all right. And it's the people who are making the representation. If you're getting loads of witnesses to sign it, it's not just one person bringing a case. It's the people. It's like, if you've got 1,000 people signed, then it definitely is a representation of the people. You're making a representation on behalf of the people. I think that's the point. You're making a representation on behalf of the people. That's the point. It is a petition. So, yeah. A petition is a representation of the people, by the people, in a special case that is being brought, but it's not a criminal case. Could end up being a criminal case, but not. I don't think in a magistrate's court. It could end up being a criminal case in the High Court. I don't know, depending on whether or not you can or can't be prosecuted, or whether there can or cannot be a plea. After 1688, this is the problem, isn't it? What you've got to do is, is that all been recognised? Is that all being recognised and acknowledged, given into the account that the Petitions Committee usually, are lame, even though we've got this Constitutional Reform Act 2005 where, the representations can be made to the House of Commons, which includes the Petitions Committee, and if there are any crimes in connection with the petitions to that committee, surely that committee to refer them to the High Court, like they do with the elections petitions, if you can be prosecuted at all. I think that's the gist of it, and we really need to do some more research. I'd like to, go into the archives. Maybe I should do it myself, but I don't really know my way around the National Archives website. I had a little look at it. It looks complicated. There are some researchers that you can hire to do research, but I think that they've used the John Beswick and Henry Burton case because they're good. They're strong casework studies through several points. It helps explain why they made the 1700 Act of Settlement, why you can't appeal a decision that's been made in Parliament, because before the 1700 Act of Settlement, obviously Burton and Beswick, they were tried by the King in his special ecclesiastical court of High Commission, and then they appealed it to the Star Chamber. So that's like, your Privy Council's kind of like, it's part of Parliament. So you're appealing a decision that's been made in Parliament for another decision for Parliament, really. But they put a stop to that. So like, once you get to the House of Lords, and you get convicted, then you can't appeal it. That's it. That's the final plea, or the final pardon, so to say. Which is why I don't think a lot of MPs they don't like prosecuting MPs or impeaching them, because they can't appeal it, really, because they're at the level where it's not to be appealed. They don't get a second chance, if they get judged by their peers. Although Lord Hanningfield, Lord Hanningfield shouldn't have been prosecuted. I don't think it was just all a stunt, wasn't it? I don't know what they were doing with Prince Philip's seatbelt fine, though. When I was out in Walpole Cross Keys, at the exact time that I was out Walpole Cross Keys, and there was a speed camera van that was interviewing to gathering evidence, that's when Prince Philip got pulled up, when he was still alive, by police for not wearing his seatbelt. Told him to put his seatbelt on, the police, and threatened him. I was out that way. He was like near Cromer somewhere, and I was on Walpole Cross Keys. We weren't far from each other, and I thought it was rather. It was on the radio, and I was like, that happened when I was there. So yeah, I was out by Walpole Cross Keys when Prince Philip got pulled over for his no seatbelt when he was out by Cromer somewhere. I wasn't that too far away. And there was a speed camera van on there as well that I ended up interviewing or getting evidence on. The thing is that I don't see how the police, on the basis that Lord Hanningfield actually couldn't be prosecuted by the Southwark Crown Court, God knows why wasn't he in the Old Bailey? Maybe it was a different area that he concerned. So I don't see why, if Prince, I can't see how, I think that Prince Philip thing was a bit bogus with the seatbelt thing, because, if he's appearing, on the basis of Lord Hanningfield and Alistair McCree at Southwark, and that Jeremy Johnson QC representation, on that basis, the police didn't actually have jurisdiction to warn Prince Philip about his seatbelt, so that was a bit of a hoax, bit of a con, That's something else I could call up. I mean, something nothing, but that was in the newspaper, so those officers could be identified, and possibly, I mean, probably not prosecute them, but they'd only gave him a warning about his seatbelt. But that they didn't have any legal authority to give him a ticket for the seatbelt. Because on the basis of Lord Hanningfield, and I'm not too sure if that Lord Hanningfield case was kind of around that time. I don't know if it had quite happened yet at that time. We could have a look actually. So Prince Philip got pulled over for his seatbelt on the 20th of January 2019. I've got the newspaper where Hanningfield goes to court. I've actually got the newspaper somewhere. It's just over there, but I'm not gonna. It's in a pile of newspapers. It's something like Lords of Leaching or something. I'll just type it in now. Hanningfield originally got accused. Who served a jail sentence in 2011. Hanningfield acquitted of. The court decides the issue is. So Hanningfield is in Southwark Crown Court on Monday, the 18th of July, 2016. 18th of July, 2016. It says here that the prosecution offered no evidence against him, but that's not true. Apparently they're trying to reckon that he'd got exclusive cognizance or whatever, and the jury... One of the newspaper reports says that the Crown Prosecutor were complaining about it. Just sent an email in at the last minute. There's some contradictory information in the newspapers. But anyway, whatever. 2016, July 2016. July 2016, 2016, 17, 18, 19. Wow, 3 years. So 2016 is when I really started getting into the investigation in 2015. So 16, I was like, that was when I was like quite really into it. And then this is towards the end. January 2019 is getting towards, well, I was about to take my driving license off me, so I was like, it was nearly over at that point, the whole thing, well, not the whole thing, but, that chapter of the story, when I actually was driving, was nearly over by January 2019. I had about like January, February, March, April, May, June, July, so like about 5 months after, but I remember this well, because I was out, and I was like, I was out that way. I was like, oh, just a minute, I was at Walpole Cross Keys when that happened. I was right near him. So this was after the Lord Hanningfield thing. So those police in Norfolk, they really didn't have a clue what they were doing, because surely Philip would have been aware of Lord Hanningfield case. He was quite highly prolific. This is why I think some of these newspaper stories are just a load of tosh. It's like publicity stunt, or should we get, Philip to get pulled over? How about if we have Philip pulled over by police and, well, and I'm not saying it didn't happen, but I'm saying that, okay, we'll have police pull Philip up when he comes around the corner, and then we can put it in newspaper, this sort of thing. Well, we'll do that Lord Hanningfield, you can't prosecute because he's got immunity, if Lord Hanningfield's got immunity, then, Philip has. So why are they pulling him over for the seatbelt? I'll just still give him a warning anyway. Let's see what it says anyway. Police speak to Philip after he's pictured driving without a seatbelt 2 days after the crash. Oh yeah, actually there was some crash. Police have spoken to the Duke of Edinburgh after he was pictured driving without a seatbelt just 48 years after his crash. he was on his own in a car and not wearing a seatbelt in images. Norfolk Constabulary spokeswoman said the force was aware of the photographs. That suitable words of advice had been given to the driver. Suitable. This is in line with our standard response when being made aware of such images showing this type of offence. Philip was in his Land Rover at the time of the crash. Oh yeah, that's what happened. He was that crash happened when I was out that way, but I wasn't at the scene of it, but I was mysteriously, oddly in that sort of vicinity. And there was that speed camera van out there as well. And it's not often when you come across them. Kind of weird. So he's got it. See, they can't actually fine him for the seatbelt. Which makes you wonder why MPs are getting speeding tickets and parking fines and so forth. Although they treat House of Commons differently. They've got Privileges Committee and they usually don't want to give them the immunity for that.